Rojas. It is a pleasure to be here today with you and to host this webinar of increasing connections from the Women in African Power. I want to thank all of you participants, and I'm sorry, I do hear a little bit of background noise. Okay. So I realize we're live, we're recording, and I do hope that in your screens you can see a slide with our with the presentation, with the name of today's webinar. So if I could kindly ask you to please confirm that you can see a slide in your screens, because we just want to make sure everyone's having access to also the visual input. So with that said, my name is Ana Rojas. It's a pleasure to be here with you and to be able to talk to you. For joining us today. And we also want to thank Power Africa, which is a US government-led partnership coordinated by USAID, for making this webinar series a possibility. Before we go into the matters, I want to run you through some housekeeping matters. First of all, you will see that participants are kept on mute, and this is to avoid disturbances. However, this doesn't mean that you are expected to stay quiet. Quite the opposite. We want to invite you to please send in your questions and comments using the chat box function on the bar toward the left of your screen. Do make sure that when you're posting questions, you make it clear to us to which presenter you're addressing your questions or comments. Behind the scenes today, we have both Maria Preble and Janie Wen supporting with all technical aspects of the webinar. So if you have issues, please do also reach out to them using the chat box function. They are the ones who will be collecting the questions, which we will pose to the panelists towards the end of our webinar. And we will be organizing future webinars towards the end of June. So keep an eye on our updates so that you know when to tune in again. The final housekeeping matter is that webinar recordings are made available online. So after today's webinar, we will be uploading the recording, and you will receive an email from us when this, together with the PDF versions of the presentations, are online for you to look at. So for those of you who don't know me and us, sorry, we are the Women in African Power Network. And if we could have that slide, which is a network that convenes and connects established and emerging female leaders who are working in the African energy sector. The network has grown quite some in the past a couple of years. And as part of the networking activities that are present, there is this need for increasing and sharing knowledge. And this is one of the reasons behind this webinar series, Increasing Connections. Today's agenda has been designed in order to ensure that you, our audience, becomes more familiar with we will have a government perspective from Lina Mangondo, followed by Chana Gluck with a perspective from the private sector. And we would close today's lineup of panelists with Nelly Magubane, who's going to share with us some lessons learned in sub-Saharan Africa. And once we've heard the 10-minute presentation of each of our panelists, we will go into the questions and answer moment. And finally, I want to invite you to join us and follow us. In case you have not done that already, you can find the Women in African Power Network on Twitter, Facebook, and LinkedIn. And if you're interested in receiving additional information about the network, please feel free to reach out to Denise Mortimer at the email that you see below. It is now my pleasure to introduce and invite Jay Govender to be our panelist. Jay is a director at the law firm Cliff Decker Hofmeier and the technical head of the projects and infrastructure practice. She has entities, municipalities, government departments, financing institutions, contractors, sponsors, and developers. Jay has experience in multiple African jurisdictions and has led several cross-border energy and rail projects. She has co-authored 3 handbooks on power purchase agreements, power project financing, and power project procurement as part of a United States government initiative in developing and facilitating power projects. Jay, the floor is yours, and we're very much looking forward to your introduction of what a PPA is. Apologies.
Thank you, Anna. Maybe that CV was a bit of a mouthful because there's certain parts that were cut off from technical glitches. So thank you all for joining today. I hope you can hear me clearly. And you can see my presentation on screen. So today I'm just going to introduce the speakers and give context to what the essence of the webinar is. And perhaps just to initially speak about the handbooks. So as part of an initiative and a deliverable of Power Africa, the CLDP, which some of you may be familiar with, but it's the Commercial Law Development Program, which is an initiative of the US government. They were tasked with developing a model PPA that could be used throughout Africa. And with this in mind, I was part of a team that was invited to Washington, DC in 2014 with a group of approximately 20 others from across the globe, and where there was representation from various stakeholders. So for example, there was representatives from the DFI, there were private practitioners, utilities, and government. There was no commercial banks or IPPs invited to this workshop. And so, as I mentioned, the mandate of this team that were being brought together was to develop this model PPA, which Power Africa and the CLDP thought could be used throughout the continent. And it was probably in the very first hour that both the CLDP and Power Africa realized that this was almost an impossible task and a highly ambitious deliverable. So what happened in the alternative at that first meeting is that we instead workshopped PPA principles and then embarked on certain training initiatives across the continent. So, the locations were Rwanda and Tanzania, but it was meant to target the regions of East Africa, West Africa, and also Southern Africa to the extent that it was convenient for utilities to attend. And what became apparent to us in the training and in the workshop was that even though electricity is so critical to every country, there was definitely a gap in fully understanding what a PPA is, how it interfaces with this concept of an IPP, which is an independent power producer, what project finance meant in this context, and concepts of bankability, etc. And that is what eventually led to the writing of this handbook. So the first handbook was on understanding power purchase agreements, and it was written in 5 days in a locked-in environment. And the essence of the book, for those of you who may have read it, is that you would see that it has almost a principles-only approach. It doesn't give an opinion either way. It's not meant to, be a model sort of agreement type guidance, but it's more about what sort of principles do you look for generally in a PPA, and what are bankable concepts, etc. So the success of the PPA handbook led to 2 further books being written, which you see on your screen. The second was on power project financing, and I believe there's already been a webinar on that book. And more recently, understanding power project procurement, and in which 2 of our speakers today were actually involved. Lena and Hannah were both involved in the 3rd book. So what is this concept of PPA? And I mean, you hear this acronym being bounced all over the place. And I think that when developing an energy generation project, there's often debate about what should be housed in a PPA. And this confusion may be understandable because it's usually a pretty complex matrix of documents that are brought together when one decides to develop an energy generation project. And there's a package of agreements, if I could put it simply. And it's not just the PPA, but generally with it comes government support and agreements supporting that, grid connection, financing, the EPC, which is the construction suite of documents, as well as the operation and maintenance once the plant has reached commercial operations. And often parties in negotiations debate about what should be in the PPA, what should be in the other agreements, what ought to be the risk allocation, what issues should be addressed, who the parties are, etc. And on my screen, I've tried to very simply set out what we try to see in a PPA. So a PPA simply is the project company, which is that IPP that's going to develop this project. Generally, it sets out their responsibility, which is to develop the project, to finance it, to construct, and to operate it. On the part of the off-taker, which is the buyer and the person who's purchasing, consuming the energy, possibly the obligations are to pay for that capacity or energy that's being delivered from that generation facility. So my discussion today is quite short, and this slide is probably as simple as it gets. It's by no means the simple, but what I try to map out is just at a very high level what sort of obligations you would typically find in a PPA. So as I mentioned, because it's an agreement for the development of an energy project and then the purchase of energy off that generation facility, the primary obligation of the buyer or the off-taker is to make payment, which is here. The seller, on the other hand, has to build, operate, maintain that power plant, as well as deliver the energy that it agreed to deliver with the buyer. The next topic is security. Generally, the buyer has to provide security for its payment obligations, and in turn, the seller provides some sort of performance security. Now, these can come in various forms, but we don't have enough time today to discuss the levels of security. Interconnection is another issue that's generally dealt with in the PPA. The buyer usually has to take care of the grid connection, that is connecting that generation facility to the national grid. And wherever there's dedicated or interconnection facilities within the context of the power plant that generally sits with the seller. Arrangements are made with the lenders where if it's a project finance deal, the seller is in charge or charged with securing financing, and the buyer then is obliged to enter into a direct agreement over the financing documents in which the lenders then secure their rights in terms of financing rights and obligations. Sorry, I'm trying to be as simple as possible, but there's quite a bit of content and substance that goes even behind lending arrangements. So then it's permits, authorizations, approvals, licenses, etc. To the extent that the buyer can assist with that, those are generally stated in the PPA, but the principal obligation to obtain permits over the power generation facility usually lies with the seller. Land, our experience is that throughout the Africa continent, land issues are quite unique to domestic law. So where the buyer does have control over the obtaining of land, generally the PPA will set out the obligation on the buyer to either grant the land or to assist with obtaining it. And in those instances where that's not the case, then it would be the seller's obligation to obtain the land. Insurance is actually a mitigation measure. It's a measure to mitigate some of the risks that generally appear in a PPA. And they could be insurance taken out for force majeure events or business interruption on the part of the buyer. And the seller, it could be quite wide ranging. FM, which is force majeure, currency, etc. What we find, especially in Africa, is that there's certainly a move towards enhancing local content through these types of agreements. And so generally in the case of a buyer being a state or utility, there wouldn't be local content obligations, but certainly on the part of the seller, we see local content obligations through, compulsory use of certain materials at a local level, labor, equipment, job creation, and where there are more sophisticated programs or and further down stages of competitive bidding, we also find that there could be obligations on ownership. Decommissioning is an issue that's generally dealt with in the PPA, and this is more prevalent in coal projects rather than other types of technology. And then just generally, the PPA also covers a whole bunch of other issues which I may not have touched here, but things like default, termination, dispute resolution, etc. Thank you. That's all I have to say for now.
Thank you very much, Jay. We appreciate the fact that you've compressed very technical information in a very simple manner. And I just want to take that opportunity first to thank you, and second to invite our audience to please send in their questions for grasping a little bit more what this concept that you just mentioned entailed. And I want to use that also as the bridge for introducing our next presenter, Lina Mangondo. She has extensive experience in infrastructure and energy. From an energy perspective, she heads up the legal team at the IPP office, and as a result of this, she forms part of the government team that initiated, formulated, and is implementing the Renewable Energy IPPP program in South Africa. Lina is also currently involved in the design and implementation of various IPP programs, principally the coal, gas, and cogeneration programs. Aside from the IPP programs, Lina also leads the team in the Grand Inga project and led the legal and policy input for the gas utilization master plan. Lina, it's a pleasure to have you with us, and we're very much looking forward to the perspective of the government and on what a PPP process is.
Thank you very much, Anna, and good afternoon or good morning to everyone. I'm I'm basically following on from what Jay has given you, which is an overview of the key principles for a power purchase agreement. But behind the power purchase agreement, or what underpins a power purchase agreement, are a set of preconditions to ensure that ultimately all parties, being the off-taker, the seller, and all the contractors and lenders find comfort in the underlying regulatory environment, as well as to the extent that the regulatory environment doesn't provide sufficient protections, contractually protections are provided to the various participants that supports the developer or investor on a particular project. For that, it is critically important to ensure that the policy as well as regulatory considerations support the power purchase agreement, and that they, from the perspective of parties coming in, that they take account and find sufficient comfort in the regulatory environment. Also, consideration needs to be given to any sector-specific regulatory framework for enabling and facilitating procurement. In any procurement process, for a power purchase agreement, there needs to be clarity on the roles and responsibilities of each of the key stakeholders. Principally, to the extent that you have government involvement, what is the role of government in the process of in the procurement process, and thereafter finalization and signing of the power purchase agreement and any other underlying agreements that give effect or enable the power purchase agreement. Associated with this is also having had an understanding of the roles and responsibilities of each of those key stakeholders. What decisions would be required from each of those key stakeholders to support the power purchase agreement prior to implementation and signing, and to the extent that there are any regulatory approvals, and identification and clarity of those regulatory approvals, an understanding of when those regulatory approvals would be provided, and the process to obtain the relevant approvals. Now, in the development of any infrastructure, it is critical to understand that this is a capital-intensive infrastructure, and from a private sector perspective, the participants are concerned about protection of their investment, while there's balancing of that of the risk associated with the investment. With an appropriate return to cover the risk associated with their particular investment. Having said that, from a private sector perspective, as well as government involvement or any off-taker in these power purchase agreements, there are following key considerations. Some of them have already highlighted, but just to again provide context, there needs to be clarity and certainty of policy from government in terms of any private sector participation in any energy project. What then is the role of states and the off-taker in that particular project? The political support is obviously the political will. Sorry, the political risk looks at what is the political will and support for the project, and obviously identifying the champion for that project, and from a government perspective, and what support is provided by the particular champion for the project. It is also important to understand from an institutional perspective, as well as looking at the stakeholders, what is the role of each of those stakeholders in a particular project, and what is their role vis-a-vis formulating, negotiating, and finalizing the power purchase agreement, as well as then what then is the support that is required from each of those government stakeholders. I've already indicated that one needs to have an understanding of the legal and regulatory framework, because that ultimately determines to what extent certain things have to be appropriately dealt with or prescribed in the power purchase agreement, or not, to the extent that there's sufficient regulatory cover for a participant coming in. Any private sector investor looking to invest in any market, including wanting to enter into a power purchase agreement, needs to be assured that there is investment protection. When it is investment, what I mean by investment protection is what are the rights that they have over that particular infrastructure. Will they be able to, at the point that they want to repatriate any returns, are they able to repatriate those returns? And there's nothing that prohibits them from repatriating any returns on the project, as well as ensuring that they will receive the payments under that particular power purchase agreement. As I've indicated, repatriation of funds is a key consideration. That is part of the investment protection, outside of obviously knowing that the plant or the particular facility will not be expropriated or nationalized by the relevant government. It is also important to understand the ease of doing business. Are there any barriers to market entry? What regulatory compliance would be required in order for, firstly, a party to set up an appropriate structure for them to participate and to enter into that power purchase agreement, as well as then any regulatory compliance issues. Economic conditions. This is similar to my earlier point around the investment protection, as well as the ability to repatriate funds, and that is a key consideration. To the extent that all of this, the current regulatory environment does not enable this, then there needs to be some sort of undertaking by the off-taker or the buyer under the power purchase agreement to either support or facilitate or enable the particular investor to be able to recoup the investment. This is of an investor or lender providing support or lending into that project. They would want some assurances at a national government level around the ability to recoup investment and ability to receive payments under the power purchase agreement. Obviously, any investment is anchored on the basis that there is a need, and that need is normally secured through the undertakings in the power purchase agreement that the buyer will have certain take-or-pay obligations, and it helps if that take-or-pay commitment is supported by an appreciation and understanding from a planning perspective of the supply-demand balance and requirements of the particular jurisdiction for the power that is the subject, or the innovation facility that is the subject of the power purchase agreement. Credit worthiness and credit enhancement go hand in hand, because that, from the perspective of an investor, gives them assurances that firstly the buyer or the off-taker will be able to buy and will be able and has an ability to pay for the particular energy, and from a government perspective that the right support, the appropriate support package is provided in the event that the buyer is not able to meet its payment obligations under the PPA, and in the event of termination, that government will stand in for the off-taker to the extent that the off-taker does not have the ability to meet its payment obligations, that government would provide the relevant compensation payments to the seller. Obviously, depending on the nature of the market, you may, over and above a off-take arrangement, you would have a regulator that would approve the costs under the power purchase agreement. And in this respect, it's critically important to ensure that there's an independent regulator for which there's no outside or external influence in the ability of the regulator to make decisions, and that the regulator makes decisions that are supportive of whatever power purchase agreement is entered into between the parties, and that ultimately there's regulatory oversight by the regulator such that all parties, including the off-taker, meet its obligations under the power purchase agreement. It is also important to ensure that whatever energy infrastructure is developed will be supported by the existing transmission system or infrastructure. In the case of an electricity generation facility, that the existing electricity grid will be able to take that power and will be capable of evacuating at a stable level the power that's being generated by the specific generation facility. Thank you.
Thank you, Lina. It has been very interesting to listen to your presentation, and I am sure our audience is already thinking about questions to pose to you. So looking much forward to the question and answer section. I would like to now invite Hannah Gluck-Abrams. She is a project finance lawyer specializing in the renewable energy sector in Africa, with experience in Zambia, Tanzania, Rwanda, Benin, Burundi, Togo, Ghana, Egypt, Ethiopia, Djibouti, South Sudan, Kenya, Liberia, and Nigeria. Previously a visiting lawyer at leading Nigerian law firm Alufko and Oyebode, Lagos and Herzog Box, Niemann, Tel Aviv. Hannah trained at Slaughter and May and qualified into a financing group at Slaughter and May, London. Hannah has published in the Renewable Energy Law and Policy Journal and received her degree from King's College in London. Hannah has recently joined the Pierpoint Allen and Overy panel of consultant lawyers and is based in London. Hannah, it's an honor to have you with us, and I would like to invite you to take the floor to listen to your presentation.
I would like to take some key elements from the PPA, perhaps going into a bit of detail in highlighting those key elements. Now, what I would say is that I come from very much with a developer hat. So I support predominantly developers in developing IPP projects in Africa. And I would also note that my experience is predominantly based, as you heard from the introduction, in East and West Africa. So some of the trends that I will be speaking about may not be applicable to Southern Africa. I would leave that to Lina and Jay to perhaps opine on that at the end of the session. So as a lawyer that supports development activities, the first step that I would take. Sorry, I'm just starting my slideshow. The first step that I would take when ascertaining whether a country is a country in which my client or the project company that I'm working with should start developing, I would first look into the investment treaty landscape. Now, investment treaties, they're interesting beasts because investment treaties, they come with no strings attached, i.e. provided that the project company or the developer is incorporated in a jurisdiction in which the country which we want to invest in has an investment treaty with, the developer would be granted substantial protections. And these protections would be automatic protections by virtue of nationality and by virtue of having the investment treaties in place. Now, these types of treaties, they would grant protections such as protection from expropriation, they would ensure that the investors' investment are protected, and they would also, they being the investment treaties, ensure a neutral forum for arbitration or dispute resolution in the event that there is a dispute. Now, my experience in the countries that I've worked with on the continent is that there aren't that many, there are some, but there aren't many investment treaties. So in the absence of meaningful investment treaties, one would have to look at the contract. And both Jay and Lena discussed the power purchase agreement. And it's within this power project agreement, the PPA, that we would start looking to confer rights on the investor that would have otherwise may have been conferred by virtue of investment treaty. Now, there's three provisions that I'd like to draw your attention to that I think would provide equivalent protections to that of investment treaties. And the first one is the change in law clause. Now, a change in law clause operates so that it provides an investor comfort that the law in place at the time of signing the PPA would prevail for the duration of the power project, for the duration of the PPA. In its current formulation, i.e. when I say current formulation, I mean the formulation that lenders would consider bankable, and we'll come to what bankable means a bit further into the session, is that it would also apply to any change in interpretation of the law or any repeal of the law. And the protections that investors would normally I would say typically expect to receive is that in the event of a change in law that puts the investor in a materially adverse situation, the investor would be grossed up, i.e. made whole, as a result of any adverse change in the legislation. A second provision that one would typically see in a PPA, which you know, Jay particularly mentioned in her session, is a force majeure clause. Now, a force majeure clause provides that if an event that's unforeseeable prevents the investor or prevents the buyer from performing its obligations, the investor would be excused from performing its obligations. Now, force majeure is interesting in the context of a PPA because in the formulation of a bankable PPA, force majeure provides certain protections to an investor. So an investor or a project company, I use the terms interchangeably, would be excused from providing energy under the PPA, but the buyer would still be obligated to pay for that energy. So that is one of the key mechanisms that are used to de-risk a PPA from a developer-investor perspective. And the third element is international arbitration, and that is to say, well, as an investor, you'll have protection that any disputes will be resolved, or we will aim to resolve in a forum that would not be prejudicial to an investor's rights. So, as I mentioned, an investment treaty would normally afford that automatically. In the absence of that, we would look into these contractually negotiated provisions. Now, another element from my experience at least, becomes very pertinent when de-risking a PPA is to look at currency. Now, there's both, as Lena mentioned, being able to repatriate offshore, but there is also the element of in what currency am I as investor going to get paid in, and is that currency liquid? Now, at least in my experience, for a PPA to be bankable, the PPA currency in which you would get paid the energy would either need to be denominated in the currency in which the financing documents are denominated, or in the absence of that, in the absence of being able to be paid in, for example, US dollars, but instead needing to be paid in Naira, there's a currency reconciliation mechanism to ensure that the investor is made whole from any negative currency fluctuations. So I know that I'm starting to speak in jargon, so perhaps let's take a step back. So for example, if I as an investor submit an invoice denominated in US dollars on day 1, but I only get paid on day 30, and in between day 1 and day 30, say for example, Naira had depreciated so much that by the time I got paid on day 30, the value of Naira had gone down significantly. I would thereafter be trued up, made whole, to be protected from that negative currency fluctuation, and that's becoming, from my experience, quite a topical issue. Now, we've also, another point for de-risking a PPA is grid risk, and this has been mentioned in previous presentations, but perhaps take a slightly more developer approach here. So who takes the risk? So from a PPA perspective, it would have to be buyer, particularly in markets that are underdeveloped, and particularly in markets in which, if we're putting on renewables, for example, onto the grid, there's been no tried and tested IPP beforehand that has attempted to do that. It's quite a significant risk for a project company to take on. So that risk is usually passed, or would need to be passed, for a PPA to be bankable to the buyer. And there's a concept of deemed delivered energy that's typically contained within a PPA. And that deemed delivered energy clause provision would stipulate that in the event that certain circumstances prevent the energy produced at the plant from being delivered to the grid, the investor, the project company, would get paid nonetheless. Now, I find myself asking questions such as, are contractual protections sufficient? So it's not uncommon for me to hear, it's fine, we don't really need to care about grid stability or the grid being able to withstand a significant amount of new energy coming on. Lena mentioned that in her presentation as a key consideration. I would fully agree with that. Because contractual protections aren't sufficient. Ultimately, as developers, we're looking to actually put additional energy on the grid. We're looking to provide communities across the continent with more energy, and I don't think that relying on contractual protections is sufficient. What is typically done, and what I certainly encourage, is effective grid studies, grid stability studies to be undertaken, potentially grid upgrades to be considered to ensure that the energy produced at the plant is actually delivered to populations in these countries. Another issue that has been I'd like to highlight here is land issues. Particularly in some countries in Africa, we have there's some very complex land tenure issues with ownership being a combination of customary and state vested land. And some of these land titles are not registered, and some of these land titles do not have actually any piece of paper to prove that these that title actually belongs to people who say they do. And I think that there has to be a lot of sensitivity in de-risking this component of a PPA to ensure that title is not only transferred to the project company free and clear of all encumbrances, but actually the communities that will be living near the project site, or perhaps even or perhaps may have to be relocated from the project site, become friends to the project and actually benefit from the project. In addition to land ownership issues, we've also got to consider land suitability of the chosen location. If it's a solar project, what's the radiation like? Is there sufficient radiation to make this project healthy from an IRR, from an economic perspective? Will there be enough sun shining to ensure that there's enough energy being produced so that the investor actually makes a return on his or her investment? Now, just to touch very briefly on credit enhancements, in some countries, the PPA in of itself won't be a sufficiently robust document from an investor's perspective in order to ensure that the investor will get paid in all circumstances. So there's a variety of instruments that have been introduced in different jurisdictions, such as a government guarantee, in which the government guarantees the payment obligations of the buyer, who may be a state entity, or a put call option that would provide instances in which the investor has the ability to put, i.e. sell the plant in certain circumstances, including expropriation, or if there has been a buyer default. Now, in an investment climate in which there's been proven track record, off-takers who have a proven track record of meeting payment obligations, that makes a more favourable investment climate in which less credit enhancements would be required. Now, in terms of, I'm just going to conclude with a couple of points. I've used the term bankability here in this presentation. It might be useful to just explain what I mean by bankability. And bankability is the ability for lenders to lend money to a project company and for equity to provide equity contributions to a project company and invest in the project on the back of the project document. Predominantly the power purchase agreement, although as Jay mentioned, there are numerous other documents that are contained within the suite of financing and project documents, whether that agreement is robust enough. Now, these standards, it's not an absolute standard bankability. It changes from jurisdiction to jurisdiction, and it changes from year to year. However, some of the, in my experience, I've had instances where in one jurisdiction, one provision was deemed bankable, and in another jurisdiction, the same provision was a no-go. So there's changing standards that one needs to be aware of, and I would suggest that there's no absolute standard. But some of the issues that I've raised in this presentation, and that Lena and Jay have also raised, I would say that those are I would suggest the minimum bankability standards. Thank you very much.
Thank you, Hannah. And again, thank you for compressing so much information in such little time and to make it so accessible to us who are not versed in PPAs. I also want to invite the audience to continue sending your questions. Even if we are not able to post them directly to the panelists today, we can always try and make a connection via email. So do send your questions and be clear as to who you want it to address your question. I would like to now take a moment to introduce our final panelist, Nelly Siwi Magubana. Nelly is the chairperson of Matlang Energy Solutions, an energy consultancy firm led and run by Black South African women. Since late 2017, Nelly serves on the board of directors of Eskom, Sub-Saharan Africa's largest energy distributor. ESI magazine has named Nelly one of the top 50 most influential figures in Southern Africa's power sector. Previously, she worked for the South Africa Department of Minerals and Energy as the chief director responsible for the restructuring of the energy sector, including planning and implementing electrification programs. She holds a Bachelor of Science in a BSc in Electrical Engineering from the University of KwaZulu-Natal. And she's also the first of the Women in Africa Network members that have been profiled as member. So if you're interested in learning more about Nelly's drive, I'll invite you to also take a look at her profile. Nelly, the floor is yours, and we're very much looking forward to the lessons learned in Sub-Saharan Africa on PPAs.
Thank you so much, Anna. And I know that it's actually on a graveyard shift here in South Africa, but I hope I'll be able to impart some of the lessons learned from 5 key countries in Sub-Saharan Africa. Now, basically, I'm going to provide you with an introduction and lessons learned from Kenya, lessons learned from Nigeria, lessons learned from South Africa, lessons learned from Tanzania, lessons learned from Uganda, and then I will conclude. I must indicate that these countries are not listed in no particular order. Now, in terms of the issues around the PPA is basically the last leg of what needs to be done by governments in order to prepare bankable PPAs. And one of those issues that we have identified as key success factors is a transparent long-term vision and planning process for the energy sector. In other words, the governments need to know exactly what is it that they envision for their energy sector. Once that has been done, they need to ensure that there's clear regulatory framework and credible institutions like the independent regulators, as it already have been explained. But more than anything else, what is important is a transparent competitive bidding process and a clear evaluation criteria that will result in a long-term agreement to ensure a healthy return on investment for the developers. But also you need to ensure that you've got a credible and off-taker with requisite enhancement and fair risk sharing. Excuse me. Now, in terms of that, so what we did, we went to look at some of these countries and then we benchmarked them against those key success factors that I've just already mentioned. And one of the areas that we noticed in Kenya was that the power sector reforms, they began in the 1990s. So they've been trying for quite a while to try and make sure that there are credible power sector reforms. But also, they made sure that they created an environment where the private sector participation was thriving. But also they had a plan. They said they want 23,000 megawatts by 2030. That's long-term planning. But also they ensured that there is a regulatory framework that was clear and with independent regulatory system. And then of course there was a competitive bidding, which has evolved over time. But also they make sure that feed-in tariffs, they play a significant role in the renewable energy projects. In particular, they make sure that they have a negotiated PPA for an unsolicited bid for their geothermal plants. But also, having said that, the off-taker had a poor credit rating, so therefore they had to ensure that there are escrow accounts with advanced cash deposits. Newly signed PPA for projects under construction with government had a letter of government support, but also what has happened is that over time they've managed to make sure that the prices decline because of their transparent procurement process. And in Nigeria, since 2001, Nigeria has embarked on one of the most ambitious power sector reforms. They made sure that they create a transparent regulatory framework that sought to establish competitive markets, which was promulgated in 2004. And also they established cost-reflective tariff and also made sure that they try as much as they can to create credit enhancement for their distribution companies, but also there were cleared labor dispute mechanisms in those regulatory processes. And then they made sure that they had a competitive bidding, which was actually rigorous, and also they made sure that technical and financial evaluations were quite rigorous. But also they made sure that there was clearly defined market rules for procurement of future power. and rules for systematic, transparent, competitiveness to make sure that they procure power at the least cost was also established. Financial sustainability, ability to collect revenue by the newly established privatized distribution sector, however, was a concern because that led to liquidity issues, of which makes the PPAs a bit risky. This was actually seen in one of their projects where the PPA proved to be quite expensive. However, having said that, Nigeria does not have an international benchmarks for competitive bids, and also they hope to have a long-term generation plan going to the future. Now, in terms of lessons learned from South Africa, I think my two colleagues have already covered this quite extensively, but I will simply reiterate it. Long-term planning with extensive stakeholder engagement is quite key. We need to make sure that we have got clearly defined roles and responsibilities, but also there should be a collaborative and supportive culture. In fact, most of the departments in the South African government actually made sure that the IPP office is well supported. That included National Treasury, Department of Public Enterprises, and the Department of Energy. But also there was a clearly defined government support package. Bankable documents with a clearly defined evaluation criteria were actually developed. Again, the procurement process must be transparent, equitable, fair, and it must be auditable. And again, you need to ensure that there is stakeholder engagement. And then, of course, you have to have well-resourced team to evaluate the bids. Lessons learned from Tanzania. The lessons learned from Tanzania is an indication of how not to do it. TANESCO is a vertically integrated utility with IPPs providing some of the generation capacity. Power sector reforms have been attempted without demonstrable success. There's been a lack of coherent planning, but also there's been some sporadic attempts at planning. However, these have been mired in politics. Memorandum of understanding have been signed with various potential IPPs without any results due to lack of skills in evaluating the value for money for proposed PPAs. There were no credit enhancement activities in the latest round of bids. TANESCO also is not seen as creditworthy. There's been lack of transparency in the planning, procurement, and contracting of power. As we speak, TANESCO is embroiled in a dispute with one of the IPPs, and it seems like they're not going to be able to meet their obligations due to liquidity challenges. The result is lack of faith in the private sector participation in the electricity sector for a country that is in dire need for private sector participation. And lessons learned from Uganda. Power sector reform included unbundling of generation, transmission, and distribution. The planning in Uganda is actually guided by the energy policy. Procurement of power is done through renewable energy feed-in tariffs, through PPPs, and also a range of tax incentives. That includes, among us, making sure that the equipment is actually import duty-free. They also have risk mitigation incentives, for example, direct agreements between government and lenders, and also they are having your take or pay arrangements. Large hydropower plants have capacity payment arrangements with the off-taker linked to annual operation targets. Bankable PPAs, various tax incentives, and tariff increases have reduced supply pressures. However, customers still yet to have to see those benefits of lower tariffs. However, this is beginning to change. Lately, we have seen a situation where procurement is now done through contracting, direct contracting, instead of competitive bidding, and we still have got to see what will be the impact of that. So, in conclusion, I would actually say for a successful bankable PPA, governments need to provide the following incentives: long-term vision and clearly well-articulated plan to execution, clear ground rules, standardized long-term contracts, effective risk mitigation or credit enhancement. Where possible, review of the industry structure in order to ensure effective competition, but more than anything else, we must have reliable timelines. So in conclusion, I can say government must also ensure that investments are made to the grid infrastructure in order to ensure reliability. Thank you very much.
Thank you, Nelly. It's been a really interesting journey you've taken us through all these countries and experiences. And honestly, and I'm sure the audience does too, appreciate the fact that you've used both good examples, but also examples where activities could have been improved. And that is also a way of learning. I would like to get started with the question and answer section. I'm conscious of the time, so we may only be able to post one, perhaps two per speaker. So if you're still interested in having your doubts cleared up, please do send them to us, and we'll be collecting them still. Jay, I would like to start with you. The questions I have are very, very simple. But still, I do hope you can help us figure them out. They are actually questions about the handbook. One of our participants is very much interested in whether it is possible not to download the handbook series of understanding, PPAs, PPFs, and MPPPs, but for buying them or having access to, physical versions of them. So there are links and they can be downloaded, but there's an interest on the printed version. And also there is a question about the audience for the handbook and how you think that the PPA handbook can be best used. What would be your tips for someone who wants to just dive into it and make the best out of the handbook?
Thank you. So on the first question, as I mentioned briefly earlier, the handbook is an initiative of Power Africa in collaboration with the CLDP and the ALSF. It is a book that's available for free. So it isn't up for purchase, and because it was funded by Power Africa. There are hard copies available, and I think that part of what we can do in this link is to perhaps put you in touch with the Office of Power Africa in the jurisdiction of whoever the member of the audience is that with the query, and we could see if we can source them a hard copy of the book. I don't know offhand the number in terms of publication, but I know that there's literally been thousands of hard copies made available and distributed at various events, conferences, workshops, training, etc. So I hope that's clear. On the second question, I think was, if I'm summarizing this correctly, is who is the target audience and how the book can be utilized. So when what I didn't mention earlier, in the build-up to actually writing the book, initially, to be honest, we thought that the target audience should be predominantly government and utilities and maybe particular ministers, where we felt that the concept of project finance and the complexity that project finance brings to a deal, and this animal of the lender and all of their very strict requirements, was something that generally government didn't get, especially since on the continent most utilities are structured in a vertically integrated way. So they held monopolies and used to basically do generation in-house, outsourcing it to a contractor at certain levels and basically operating these plants on their own. So the shift to IPPs is something that is not generally a comfort zone to most utilities and governments on the continent. However, to our surprise, what we found, based on feedback, based on our interactions with private sector, commercial banks, etc., the feedback we got was that even the private sector found these books so useful. And some of our clients who are commercial banks, my colleagues who are other attorneys, developers, have used it to train their juniors or to upskill themselves on certain principles that they may not have come across in the particular jurisdiction. So I think whereas initially we may have a particular mindset, really the feedback we've received is that it is a useful tool for almost every single stakeholder in the value chain of a development of a generation project. Thanks.
Thanks, Jay. I think there is no bigger compliment to you and to all the other authors to hear that it's so well received by so many different actors of the value chain, as you say. And yes, I think you made a great effort also to answer the question on the resources. I do have a suggestion also following your lines, is that this person, if this person could just reach out to Denise Mortimer at the email that is showing on your screen. Denise could also put you in touch or try to figure out a way of helping you have a hard copy of the series. I would like to go now to Lena. And Lena, there's a very specific question we've received for you. It reads as follows: is there a power purchase agreement
Hi, everyone. This is Jamie on the technical side. I just wanted to fill in the question for Lena. The question was whether there is a power purchase agreement for Grand Inga, and if so, would it be available for the general public?
At this stage, there is no power purchase agreement for Grand Inga. South Africa and the South African government and the government of the Democratic Republic of Congo have entered into a treaty to enable the Grand Inga project. But developments on that project have stalled at this current, they're on hold at this current stage.
Thank you so much, Lena. Nellie, we have a couple of questions for you, if that's all right. The first is about the lessons shared and whether or not they reflect consumer experience. For example, in Uganda, there has been a lot of issues with very high tariffs due to the way hydropower PPAs were structured. And the question is to ask if you have any comments, Nellie.
Can you repeat the question? I didn't get it.
Oh, the question is that the lessons shared may possibly not reflect the consumer experience. And the example given was that in Uganda, there was issues with very high tariffs due to the way hydropower PPAs were structured. And so the questioner was asking if you could please comment on that experience.
Yes, yes, absolutely. In fact, If we go back to the presentation, that is exactly what I said. I said that the supply pressures have been minimized. However, the customers have not received that benefit. So in other words, the tariffs are still extremely high because what happened was a lot of effort was put on enhancing the PPAs and creating all the kind of incentives in order to attract the investors in the generation sector. However, the customers are still paying quite a lot of high tariffs at this point in time.
Thank you, Nelly. We also have a question here for Hannah. Hannah, could you identify any social or gender risks from your experience and specifically how to mitigate them within the PPA framework?
Would it be possible to repeat the question, please?
Of course. The question was to ask if you could identify any social or gender risks from your experience, and specifically how to mitigate these types of risks within the PPA framework.
It's a very interesting question, and at least in my experience, it's not necessarily dealt with as part of the PPA, but it's dealt within the broader context. So, for example, as part of, I mentioned acquiring land, as part of the acquisition process or the lease process, so the process of obtaining title to the land, an environmental and social impact assessment would typically be undertaken to assess the impact on the environment, but also social implications. So to the extent that there are vulnerable people, perhaps children, perhaps women involved in that relocation, or perhaps there's a sense that compensation payable for that land would not reach them. A framework could be implemented to ensure that those considerations are addressed. But that's more within the context of the project as a whole, rather than specifically within the PPA document itself. I mean, that's been my experience at least. I don't know if other panelists have had different experiences.
Thank you, Hannah. That's really interesting. And we also had another question for you, if that's all right. There was a questioner who had a question about specifically an experience in Nigeria. They wanted to know if you could talk a little bit more about FX hedging as an alternate, or perhaps maybe other better alternatives as mitigation strategies for companies, especially considering the challenges that Nigeria has faced and does continue to face to meet its obligations as a result of currency depreciation.
Yeah, I mean that's a very topical question, and right now the key consideration, hedging mechanisms for in my experience have not been considered, but other projects may have considered that. Within the Nigerian context, at least in the current framework, the issues are less around the FX gross up, but more about the availability of dollars. That the naira has been quite volatile recently, and there has been a period of time in the not so distant past in which access to dollars was not possible in any within the main market, not the parallel market. And the government was not willing to guarantee the availability of dollars in the PPA. So that was one of the key risks that that investors faced within the context of IPP, with IPPs, but other sectors as well. But we're talking about IPPs here. So perhaps hedging is something that can be explored and may possibly be explored as at least the solar IPP program, which I'm involved in, will pick up. But hasn't currently been considered within the solar program.
Thank you so much, Hannah. We also have another question here, and I was wondering if I could ask both Jay and Lena to weigh in on this one. The question is, what other options to ensure credit worthiness are available so that the taker can be proposed in case a government does not provide state guarantee and no liquidity support?
You have the MEGA guarantee option from the World Bank. Other international DFIs are looking at various other risk mitigation guarantees or support in lieu of support or credit enhancement support from the host government.
Yes, just from my part, I think I'm going to take the easy way out. When we wrote the second handbook, it's entitled Understanding Power Project Financing. And for those of you who have read that book, that is essentially the essence of the book. The context of that is that we did an analysis of projects on the continent and looked at some of the principal reasons why projects don't close. The topic of credit enhancement, government guarantees, etc., was very much high on the rank because the trend in Africa is not to provide a government guarantee, I'm not sure where it stems from, but certainly there is resistance to providing government guarantees for generation projects. So if you do read that handbook, what that addresses is all of the alternatives. So if you don't have a government guarantee in a project, what are all the different credit enhancement tools, mechanisms, etc., that you can utilize over the tenure of a power project in order to at least get lenders over the line and achieve a bankable project. Thank you.
Great, thank you so much. And we have one last question before we're going to start wrapping things up and ask the presenters to kind of give us their key takeaway messages. So Nelly, this last question is for you, and it is about a kind of observation with some follow-up questions. The observation is that the governments, specifically in Tanzania, now seem to be wanting to review long-term PPAs and are much more keen to do shorter-term ones. What are the implications? If you could please elaborate on the shortest-term PPA that can still yield the best results and how this can possibly be structured.
What I would say with regards to Tanzania, I think it's time for those PPAs, the long-term PPAs, to be reviewed because they are so unfavorable to TANESCO. And of course, with regards to the short-term PPAs, they do have those short-term PPAs, but only for emergency power. So, however, whatever structure that is going to be coming up on the side of the PPA, I'm of a firm view that there needs to be a lot more work that needs to be done in order to make sure that those PPAs are actually bankable. Because at this point in time, they are not favorable for TANESCO, and unfortunately, they are not getting enough tariff for liquidity in order to be able to enhance that.
Okay, great. If I could then now ask all the presenters to please give us a short takeaway of a key message that you'd really like to impress upon all the attendees, that would be very welcome and a great way to close this webinar. If I could ask Jay to step up first, that would be great.
Yes, thank you. So just very quickly, and I must say thank you to all of my colleagues for very insightful discussion, and those of the audience that are in this space know that it's, again, I've used the word complex a few times, it's highly complex. So trying to simplify all of the concepts in just an hour and a half is not an easy task. So just very quickly, my takeaways just listening to today's webinar is, one is that an optimal PPA needs to be jurisdiction specific, and there isn't really a precedent out there that one could use from one country to another. You got to apply your mind to the jurisdiction that you are. I think it's very important to de-risk the generation project to the best extent possible. And this can be done through various mechanisms, planning, early government involvement, a solid PPA, and by various stakeholders. And the result ultimately will be cheaper tariffs if this is done properly. I think we heard a lot about risk. Obviously, there needs to be a balanced risk allocation. It's important to understand the market that you're playing in, especially from a regulatory perspective, but also from an investment perspective, etc. And lastly, I want to say that I thought Nelly's snapshot of the different countries was really excellent, because if you take a step back and you look at the various lessons learned, it's amazing how the things that went wrong or are wrong or going wrong seems to be repeated. So I think that we do need to learn from each other, learn from our neighbors, learn from the best practice, but still keep it unique to your country so that these deals can close. Thank you.
Thank you so much, Jay. That is excellent advice. If I could please ask Lena as well to let us know what your key messages and key thoughts are from this presentation.
Thank you. I would say I echo more or less the same sentiments that Jay gave in her wrap-up. It's important to ensure that ultimately there's clarity of the roles and responsibilities of each of the parties, and obviously understanding of risk and which party is best placed to deal with that risk in assessment of who needs to take on board the risk. Obviously, key considerations in any power purchase agreement are around the financing, ability to recoup the investment, and as well as not only on the project, but for sponsors to be able to repatriate the funds. China mentioned issues around foreign currency exposure and who takes that risk, and the impact that has on the ability of the investors to recoup and repatriate returns. Nelly gave perspectives which were brilliant on the different lessons and approaches in sub-Saharan Africa on deployment of renewable energy plants. And we must always be guided by those lessons learned to try and ensure that in formulating any procurement or in wanting to get private sector investments, we don't make the same mistakes. But ultimately, all of these investments are underpinned by the various credit enhancement instruments. And as Jay said, one would need to look at the handbook that has been formulated that deals specifically with credit enhancement. Thank you.
Thank you so much, Lena. And could I ask Hannah if you could also let us know what you feel the key message that you would like the participants to take away from today are?
Yeah, can I just first say that on today's session, I felt that I was both a panelist and a member of the audience. I want to thank my colleagues for their very informative sessions. I learned a lot today, so thank you. From my perspective, a key message that I would like to convey is that there are these minimum standards that investors and lenders would want to see in a PPA in terms of the allocation of risk, particularly the entity best placed to take on the risk takes that risk. But I would echo what Jay says, is that bankability and that risk allocation will change from jurisdiction to jurisdiction, which would depend on a number of factors, including the investment profile of a particular jurisdiction. It would also include the credit history of the buyer and a number of other factors. Liquidity is another example. So these standards are constantly evolving, and to take an agreement from 2011 and apply to 2018, or take an agreement from 2017 and apply to 2018, those standards may have moved on. So that is why taking advice and also attempting to be creative and not simply working on what's done in the past may prove to be a useful tool when approaching the possibility of investing in an IPP in Africa.
Thank you so much, Hannah. And Nelly, certainly last but not least, we would love to ask you for your insight on what you feel the key takeaways are as well from today. Thank you.
No, thank you very much. And thanks a lot to my esteemed colleagues for very, very, very important and informative and brilliant insights into PPA, understanding PPAs. All I can say that we are all having a responsibility to make sure that we create an environment that is going to make sure that there is more energy that is being deployed. It's really not right that in the 21st century, the African child is still actually suffering from the shortage of energy. So I'm of the view that whatever takeaways that you have, let's simply just go back there and make sure that we make energy happen.
Thank you so much, Nelly, for that very passionate reminder, something that is very important for all of us. And I want to make sure to thank all of the panelists for your contributions to this wonderful conversation, and to the participants as well. We certainly hope that this has been an informative and engaging discussion about PPAs, and that it supports you in your work and in your investigations into the sector. And we always remind you that we are always here. You can contact us for any questions or further information, and that the video and presentation from today will also be made online shortly. And finally, we of course want to thank Power Africa for their wonderful support to the Women in African Power Network. And thank you for joining us today. Thank you.
Thank you.